esteemed speaker, Advocate Sumit Chander, sir. Sir is a practicing lawyer at the Delhi High Court and have an experience of more than 15 years in the field of litigation. Sir started his career in the year 2002 with civil, commercial, and constitutional cases. Sir had also filed the PIL, which resulted in establishment of 18 courts and 22 commercial courts in Delhi. Sir is a mediator with the Delhi High Court Mediation Center and has done an advanced mediation training program from the University of California. Also accredited in commercial mediation by the Indian Institute of Corporate Affairs. Sir has been awarded the National Law Day Award by Dr. Justice K.G. Balakrishnan, former Chief Justice of India, for his education and vast experience, which played a critical role in development and recognition of the international mediation and arbitration. Thank you, sir, for being with us today.
Thank you. Thank you.
Now I request Sumit Chander, sir, to start with today's webinar.
Sure.
Over to you, sir.
Thank you. Thank you, Mr. Nitesh Mehra and your team, Ms. Zoya Mehta and Ms. Komal Vashisht, for inviting me today to speak on this very interesting topic of pleadings and drafting. Now, many young lawyers and law students feel that drafting is the most difficult part of work in law, but that is not the case. I have, from my experience, made a certain set of systematic process, which if you follow, you can do any legal drafting. Of course, it needs hard work, but it's no rocket science. I have made a small PPT to make it easier for you to understand. And let me begin with putting the PPT on this screen. I hope the PPT is available and visible to everyone. Can you confirm it?
Yes, sir, it is visible.
Yes, sir.
Thank you. So we will be discussing pleadings and legal drafting, and I'll be telling you the techniques on how to do it. But before we begin, let us understand what are pleadings. Now, pleadings have been provided under Order 6, Rule 1. Now, what are those under Order 6, Rule 1? Order 6, Rule 1 says that pleadings include the plaint and the written statement. And even before we go further, let us understand the court procedure. Okay, one second. The court procedure, when we talk about, it includes first a plaint is filed in the court, then the written statement, then the replication. Once these three things are filed, we say pleadings are complete, though the Order 6 does not talk about replication as part of the pleadings, but as a matter of process, replication is generally included. After that, there is an affidavit of admission and denial which is filed and has been explained in Chapter 7 of the CPC. Then we talk about framing of issues, plaintiff's evidence. So once the issues are framed, now it's very interesting when the issues are framed, the court generally puts, by framing each issue, between, after each issue it is said OPP or OPT. Now, this is very interesting. Do you know what is OPP and OPT? Well, friends, OPP stands for onus of proof on the plaintiff and OPT stands for onus of proof on the defendant. So every time an issue is framed, the court also says that who will prove this issue, whether it will be the plaintiff or the defendant, and that is why the need for writing OPP or OPD. Then comes the plaintiff's evidence. The next process, plaintiff is the person who will first provide for his evidence, conduct his evidence, give the evidence of the plaintiff by way of, in a civil suit, by way of an affidavit, and then it is cross-examined by the opposite side. We call this process the plaintiff's evidence. After the plaintiff's evidence, comes the opportunity for the defendant's evidence, in which case the defendant files his affidavit and is cross-examined by the plaintiff's counsel. Then the arguments take place and the judgment is passed. So overall, when you look at it, this is the court procedure which is followed. Now coming to drafting of the plaint. Drafting of the plaint, let me begin with quoting Shannon Hale. Shannon Hale had said that I am writing a first draft and reminding myself that I am simply shoveling sand into a box so that I can build castles. Rightly said, the first draft is nothing but collecting the data. Collecting information is actually the most important part. Now, I have another interesting joke on this I will now show, where collecting of data, why is it important? Say if I offered you $100,000 to jump from a plane without a parachute, would you do it? I bet you would say no. But what if I told you that the plane was on the ground? Moral of the story, know all your facts, which is very, very important. So even for drafting, you must collect all your data, all your information before you begin the drafting. So that is why I have divided or put the drafting of a plaint in 4 phases. In the stage 1, which I call the paper sorting, I will explain it how. Stage 2 is the client meeting. Stage 3 is the legal research. Stage 4, rough draft. And stage 5, you make the final draft. Now let's understand one by one what it is about. So when we talk about stage 1, which is paper sorting, in this case, the client gives a background of his case. When the client is talking to you and giving the background of his case, listen to him, collect the data, collect all the information that he gives you, and draw a sketch in your mind. And then that person will leave, leaving a huge bundle of papers with you. What you need to do is put a date of the document on the top right corner of each document. I generally say it with pencil so that you can later erase it if required. Then you must study each document carefully. Studying a document will change with the need of each stage. Now in the first stage, while studying the document, you need to focus on what is the date of that document. Now it's very interesting because there are instances where a date would be written on the top of a letter, and towards the end while signing, the person has written another date. So which date do you choose? So similarly, you need to understand and write the correct date of the document. Then you make a list of date, event, and source of info. I put that in a tabular form. The date has to go on like a storybook from the oldest to the top and the latest at the bottom. With each date, you will write the event, and in the source, you will mention whether that date comes from the title of the document or is it a date which is mentioned in the document. Maybe that document is a letter talking of 2020, talking about an instance of 2010. So 2020 will come on the first as the title of the document, and in the next date of 2010 when you're mentioning, you will mention that it is mentioned in so and so document. Now this list of dates will keep expanding. I'll tell you how, which we come to stage 2. Now you have, sorry, somebody's saying something? Okay.
No, nothing, Sumit, you can continue.
Now, there's somebody who's drawn a line on this PPT. If that can be removed, it will be great. Okay. Stage 2, we talk about the client meeting. So once we have a list of dates ready, we can again call the client for a meeting. And this time, we are very sure about the list of dates and the documents that we have now studied, that what exactly is the story. So we ask the client for a story with the approximate dates, what he would remember. But when the client is telling him, you confront him when his story will not match with your list of dates and events. You confront him with those documents. And I'm telling you from my experience, several times, in fact, mostly the clients, when they talk about a certain list of dates, it doesn't match with the documents because they believe a certain thing to be true. But yes, when you show them the document, they will agree with you, and then they will accordingly change what they have to say with respect to that instance of a particular date. Now make the notes of his list and dates and fill in the gap in your current list of events. So how do we do this? Now the same date, event, and source, only changes. Now you will have another column where you will mention that the source of information is the client himself. With this, you will be very sure when you're preparing a draft or even arguing in the court that which are the documents or which are the events that you can easily prove as you have the document to it, which are the events you can prove by virtue of depending on a document which mentions that list of dates, and which are those events which you will not be able to prove by way of document, but you will have to take it out in examination or cross-examination in evidence, which is the source of information from the client. In stage 3, we come to legal research. Now you're very sure of the facts you've got from the documents as well as from the client. So what do you do now? Now you read the relevant judgments and precedents. You must ensure that your facts are supported by those judgments. And invariably, when you do your research and if you do it properly, a lot of your facts have already been taken up in some other case where it has reached the High Court and the Supreme Court, and Supreme Court or the High Court has mentioned whether these facts mentioned by you have resulted in that case in the favor or against of the party. Then read the relevant provisions of law. Now, my friends, this is very important. A lot of us have this tendency that we take up a draft, copy it from somewhere else. You should not do that. Read the provision of law. Say, for example, it's a writ petition under Article 226. Read it. And trust me, every time you have a case of the same kind, read the provision of law again and again, and you will see that your interpretation with respect to that provision of law keeps changing with every new case that you prepare. So that is why reading the relevant provision of law in each time you draft is very, very important. Then you note down the ingredients of the law with pointers. Say, for example, now what are ingredients of law? It's basically understanding, say, for example, Section 138. Section 138 gives an entire explanation about how an offense is committed under the Negotiable Instruments Act. But when you're preparing a case, you need to cull out the ingredients from this section and use those and ensure that your drafting covers all those ingredients. Now all of you would be aware of Section 138 Negotiable Instruments Act, so I'm not going to read it out to you. And I will straight away come to the ingredients of this section. And all these ingredients have been taken out in words as close as possible from the section itself. The first ingredient becomes that there should be a check drawn by a person on an account maintained by him. It's very important because when you draft, you have to ensure that this comes in your drafting. Then the second ingredient is that it should be for payment of any amount of money to the other person. Third, it should be for discharge in whole or in part of any debt or liability. Fourth, it should be returned by the bank unpaid for the reasons insufficient or exceeds the amount arranged. Now, technically, if you have covered these 4 ingredients in your complaint that you're drafting, you would have made the perfect complaint under Section 138. obviously adding these ingredients to the facts which you have now prepared in your list of dates and events. Now you have the facts and your law, so you start preparing a rough draft. So keep the final list of events in hand. Name the title. Draft the paras introducing the plaintiff and the defendant or the complainant or the accused, depending on what case it is, or a petitioner and a respondent in some petitions. So draft your paras first, introducing them. Who are these people? What kind of a relationship do they share? Are they a husband and wife? Are they a business, a principal or an agent? So that defining and introducing them and defining their relationship is a very important part. Fourth, once you have introduced them, then you put your list of events in a story mode. It's very simple. You already have your facts very clear in front of you. What you need to do is prepare this list of events. Same thing, you put it in a story mode, making it clearly understandable as to what the case is. Then you write the mandatory paras as per the facts of the present case. Now, what are mandatory paras? Let us understand this, because your first and the middle portion of your drafting is complete. The last part is your mandatory paras, and we are now going to discuss the mandatory paras. Now, mandatory paras have been clearly defined under Order 7 of the Code of Civil Procedure. One is the cause of action. You must mention in your drafting, after you've completed those facts, that how has the cause of action arisen in your case? What makes you file this case? Then the territorial jurisdiction. This is specifically, it's a mandatory para. Of course, you have to mention it. That how this court which you are now approaching by way of your draft, is the court to adjudicate upon this by virtue of its territory it's located in. Whether it will be filed in Saket court, in Tisazari, in Rohini, in Dwarka, or maybe some out of town. So territorial jurisdiction you must mention as to how that cause of action has particularly, or part of the cause of action has arisen in the territorial jurisdiction of that court. Then the pecuniary jurisdiction. In Delhi, we have our jurisdiction for a district court. It's a certain level. High court, it's different. Accordingly, you decide what is the amount involved in your case to be decided whether it goes to the district court or the high court. Then comes your limitation. Whether you are covered within the limitation prescribed under the Limitation Act. Then you must mention the value of the suit and the court fees that you are affixing. Whether it is under the Court Fees Act. Of course, we have our court diaries to refer to those lists given to simplify how to calculate the court fees. But of course, it should be under the Court Fees Act and valued as per the value of the suit. Last but not the least, your prayer should come. Keeping all these things, the rough draft is ready. You must reread your draft and keep these following things in front of you. The file, basically to refer to the documents, the list of events, to tell you which event is relying upon by which document. So accordingly, you can choose which document will become annexures to your suit, and the rough draft. Give a final reading to your draft. Check for a clear storyline, grammatical errors, etc. I've seen this tendency that a lot of people just simply get on and start with their first draft in a manner that they don't intend to give it a second reading. And interestingly, when I was working with my senior, I would ask him, sir, how do I improve my drafting? And he said, there's only one way. When you do your drafting, read it, then reread it, then reread it. And every time you do this rereading, you will see you will make changes in your own draft and your drafting will improve gradually with time. But this is the hard work that you need to put into your drafting. Now, when you're giving the final reading to your draft, ensure that there is no missing link. When I say this, I mean, when you're talking about a story, it should be connected to the other part. Say, for example, when you mention that an incident has taken place in a school, you must mention how that school has come into that picture. You can't simply say that an incident has taken place, but in the school there was nobody. Where has that school come in? So unless you tell in your sequence of events that the incident took place in this particular school at this particular time, only then will you be able to talk about further referring to that school. Ensure that all your ingredients of law are fulfilled. This is very important, which I just told you by example of a complaint under section 138. Then make sure that your supporting affidavit is there. Now, what is this supporting affidavit? Supporting affidavit has been mandated under Order 6, Rule 15, Sub-Rule 4, that every plaint must be supported by a supporting affidavit. Now, what does this supporting affidavit include? One, the person deposing this affidavit, how is he competent to depose? Is he the plaintiff or a party in that case? That is how he's aware of the facts of the case, and that's how he is competent to depose this. Secondly, that whatever has been drafting, the accompanying plaint, has been drafted under his instructions. And in cases where he does not know how to read or write English or the language in which you have drafted your plaint, then you must enter a para which says that the contents of that accompanying plaint has been read out to me in my vernacular language and has been understood by me. Then no part of the accompanying pleadings is false and nothing material has been concealed therefrom. Last but not the least, once you've put all these 5 points in your accompanying affidavit, in an affidavit format, you get it attested by an oath commission. So basic points that you need to keep in mind while drafting anything. Please keep your language very simple. There should be no repetitions. Use words as much as possible from the documents. This is very important because when it comes to the court at the time of argument and you use a word, the court may ask you, how do you say it? At that moment, you should be able to say, my lords, it's not me who's saying it, it is this document which is saying it, and you may refer to so and so page for that document. Avoid long sentences. A lot of people have this tendency to make long sentences using and so, and this happened. Avoid it. Use as many full stops as possible. You will find that when you use short sentences, your drafting, your clarity in whatever you want to say is much more clearer as compared to long sentences. And pleadings should be very specific. There should be no ambiguity. Prayer also. Now this is very important. Pleadings, they make a very good pleadings, but prayer, generally they leave out as not very specific. Now here is an incident in a case which I dealt with. It was a consumer matter many years back. I was in the court. I was appearing for the company which manufactures refrigerators. And the company had given me instructions saying that in case the party's other side is ready for a settlement, I may either allow refund or replacement. So the court put this to the complainant who was appearing in person and asked him, what do you want? Now the complainant was not very clear about his prayer. He said, my lords, this refrigerator they gave me was very faulty. So I want to teach them a lesson. The judge asked, that is okay, you want to teach them a lesson. But what do you want? Do you want a replacement or a refund? Again, since he was not very clear with his prayer, he said, Lord, I just want to teach them a lesson. Finally, he didn't get what he wanted. Settlement did not take place just because he was not very clear on the prayer. Then choice of words is very important. Why I say this? In fact, this is a case, a very interesting incident which happened with Mr. Nani Palkiwala. There were these gas manufacturing companies which would take from the dealers a lot of cylinders. They would fill in the cylinders, but sometimes the dealers would not come and collect it back. So since their cylinders would keep occupying the space in the premises of the manufacturer would start charging them rent on those cylinders. Now, the moment they would charge rent, they would become liable to pay tax to the government for the rental income. So they said that, listen, we are not using this as an income. We are only using this clause as a deterrent so that they don't leave their cylinders in our premises for a long time. But anyways, since they were being taxed, so they go to Mr. Nani Palkiwala. Now, Mr. Nani Palkiwala, very interestingly, obviously charging his fees, he said, choose your words properly. Don't call it a rent. Simply call it the cylinder keeping charges, and you won't be taxable because there is no tax on cylinder keeping charges as it is on rent. So now you see how the choice of words is also so important. So now coming to contract drafting, just a small sample I'll give you. As an example, before we begin the contract drafting, and like I said, even in pleadings, you have to be very specific. Now, say for example, if I were to give you an orange, or I were to give an offer to orange to someone, how would you offer it? Well, one is you just offer it by saying, here sir, please have this orange. Other is, as a lawyer, you can say, and specifically so, I hereby give and convey to you all my rights, interest, claims and title to that said orange, along with all its rind, juice, pulp and seeds and all advantages thereto, with full power to bite, cut, freeze or otherwise eat the same, or in any manner give the same away to any person with or without the pulp, juice, rind and seeds. So now you see how being specific is, or how you can be specific. But do you know why being specific is important? Now let me share with you two very interesting cases of, obviously, from way past. This is the story of Akbar and Birbal, a contractual dispute where the importance of being specific was held, and the smart way you were able to come out of that contract because the terms of the contract were not specific. So once a man sold his well to a farmer. Next day, when a farmer went to draw the water from the well, the man did not allow him to draw the water from it. He said, I have sold you the well, not the water, so you cannot draw the water from the well. Well, Birbal as he is, he saw the ambiguity in the clause or in this contract, and he came up with the solution, the exit clause, where he said, since you have sold the well to this farmer and you claim that water is yours, then you have no right to keep your water in the farmer's well. Either you pay the rent to the farmer to keep your water in his well, or you take it out of his well immediately. Simple solution, simple way out of an ambiguous contract, a contract which was not very specific. Now there is another very interesting Shakespeare story, The Merchant of Venice, where again the same issue of not being specific in a contract or an ambiguous contract was existing. What was this? The Merchant of Venice. It's a 16th century play where Antonio was short of money because all his wealth was invested in his fleet which was currently at sea. So he goes to a Jewish money lender, Shylock. Shylock hates Antonio, but he agrees to give him a short-term loan on a condition that the loan must be repaid in 3 months or he will extract a pound of flesh from Antonio. Now, Antonio agrees. He was confident that his ships will return, and Shylock was happy that in case he doesn't, he will get his revenge and will be able to extract a pound of flesh from Antonio. Unfortunately for Antonio, his ships were wrecked and the date for repayment to Shylock was passing away. So Shylock demanded his pound of flesh depending on the contract. Like I said, again, this was an ambiguous contract, not specifically or not well drafted, and see what happened, how the exit clause was made in this case. The decision was taken that Shylock can have the pound of flesh as long as he doesn't draw the blood, because the contract did not allow him to draw the blood, only allowed him the pound of flesh. So he could not take the pound of flesh. Again, the decision went in favor. Exit clause was used by taking advantage of an ambiguous contract. So please, whenever you draft your contracts or agreements or even your pleadings, be as specific as possible. Now, what are the important legal points that you need to put in your agreements? Number one, termination. The exit clause, like I said, it's important. How it's going to be terminated? Who will have the option to terminate the contract? Whether both, whether one, whether it will be on notice or whether it will be only on happening of a certain event. Notice. If I am to serve a notice under the contract for any purpose, be it for termination or for any other purpose of the agreement, where do I serve that notice? Today, you have the advantage of putting the mobile numbers and emails and service of notice even on those contact addresses and phone numbers is made valid under law. Then comes indemnification. It's very important that your client is indemnified by any act of the other side in case there is a failure to perform the contract. Arbitration and mediation, very, very important clauses nowadays. Mediation, it will help people sort out their differences even before they go to the court and obviously save a lot of costs. So now in the contracts, we have started putting a mediation clause that in case of any dispute arising from this contract, the parties would be referred to mediation, maybe of the Delhi High Court Mediation Center or to any mediation, private or otherwise. In case that mediation fails for any reason, then the parties can go for arbitration. Again, the jurisdiction becomes a very important part in your legal document, because you need to mention, especially where the parties are from two different states or two different jurisdictions, you must mention which state or which country will become the jurisdiction for approaching the courts in case there is a dispute arising from that agreement. The force majeure, last but not the least, is very, very important in scenarios. We are already passing through a pandemic, which some courts have held as a force majeure situation. But that situation or the force majeure clause must be there in your contract, which says that in case there is any act of God because of which the contract is unable to be complied with or fulfilled, then it will be suspended for the moment till the force majeure remains. So friends, keep these simple things in mind. Your pleadings and draftings will be made much more easier. Of course, it does not take away the hard work. You will have to keep working hard, keep reading, rereading your draftings, and you will be able to draft anything on this planet. Thank you so much.
So yeah, please look into the chat box if you find any questions, because I didn't see any questions. Sumit sir has explained it in such a nice manner that
I
there are
think
no
everybody was
questions
so
lined up.
glued. Everybody was so glued to the presentation with all such beautiful examples given by sir.
Yeah.
I request everybody to ask questions, please. If in person, I can even do that. Please go ahead and ask your questions.
I like this Birbal one, what he drawn, that's like so wonderfully he has drawn and weighted out the clause. So
Yeah,
it was
these are
something stimulating.
practical examples.
So, sir, I mean, if I may ask a question since
Yes,
everybody is yet to ask.
yes,
Sir, like the virtual platform, the use of virtual platforms are increasing. So,
right.
how do you see? I think there's going to be more of use of written statements and written arguments. Written everything is going to be in writing. So, how do you see the future of lawyering now in
See,
this coming scenario?
we have already somehow started shifting into these small phases of modernizing our legal profession. What has happened was recently I had this client who said, "Ki, can I come over to your office?" Like I said, the client would come and hand over these papers. I said, "Sorry, please just make a PDF, scan your documents, send it to me. And so far as your communication or meeting is concerned, we can do it over Zoom or even phone calls." So times are changing. And we, even to the courts, when we are filing a document, we are filing it through online by way of email, taking a date on phone, and court hearings are also taking place through WebEx and other video conferencing apps. But what is the problem which we need to still work upon is that somewhere the say simple aspects like the attestation of the accompanying affidavit, which I said is mandatory under the Code of Civil Procedure. How are you going to get an oath commissioner to attest it now if you want to avoid a physical presence? Maybe they will come up with digital signatures or some other concept of digitally attesting a document. But again, that needs to be seen how it's going to work out. There needs a lot of amendments that needs to come in by the parliament so that the courts can actually function more electronically.
So Sumit, there is one question I just received in my private chat box. It
Yes,
says, don't you think, sir, since we are going virtually, though
yes,
it's very nice idea, but as you said, these pleadings has to be attested by an affidavit. I think the same which you have just told to everyone. And it further says that affidavit, if not there, how can we later on have some party to be made guilty under 340 or not? Because when they have not sworn in this affidavit while filing the plaints right now in the virtual hearings.
right. So, of course, the supporting affidavits what we were talking about, not the affidavits on for statements given in the court. Evidence is still a very important part that has to be considered as to how the evidence is going to be taken up before the magistrate, which are important provisions of law. So I'm sure you would have covered those evidence in other lectures and webinars you would have done. But so far as your drafting and court procedures are concerned, yes, like I said, legislature needs to come up with certain amendments. We have an Information Technology Act, but that needs to be amended. The procedural laws, the Evidence Act, the CPC and the CRPC needs to be amended, and new ways have to come up. He is very right, the person who's asked this question, that yes, how do you make a person accountable for an affidavit on oath if he makes a statement, if we are not filing an affidavit along with the pleadings? So yes, these are things which are still on a gray area, which will get covered soon either by precedents or by the legislature by making these amendments.
Thank you, Sumit. There is another question on my again private chat. This is asked by Ankit. So yeah, he is saying, sir, how to draft an cause of action paragraph when the court we know that does not have the territorial jurisdiction, and how to include the territorial jurisdiction when we are on the side of the plaintiff. I think it's an important question which has been asked.
I think Ankit needs to further clarify exactly what he wants to know. But from what I can understand, see, cause of action you have to mention. Without a cause of action, there is no reason for you to come to the court. So of course, cause of action, you can't say I don't have a cause of action. But the cause of action would have taken place in a certain area. Now, How you define that area will again depend on where the cause of action has taken place, what was the incident, depends on the facts of that case. So depending on those facts, you have to see where the incident has taken place, and that will become the territorial jurisdiction for that case. So it will change from facts of the case. Zoya Mehta is on mute, so we can't hear her.
So, yes, sorry. There is a question from Mr. Sachin Baduni. He asks, generally, I have seen indemnity clauses in the commercial agreements rather than damages clauses. Why so? This is his question, sir.
See, indemnity is important. Now, what happens is once you are anyways indemnifying a person, you are taking over or assuring yourself that in case something goes wrong and I am to bear the expenses or bear the losses for it, anything that I bear will be taken care of by that person. Generally, along with the indemnity clause, we also put in a damages clause. Like I said, again, it's from drafting to drafting. Now, one, of course, you've indemnified for the loss, but beyond the loss, I have also suffered other possibly the other damages, what I would call in the other losses in terms of mental harassment, in terms of other problems that I face because of non-performance of the contract. In those cases, we can also ask for damages. But yes, once you're indemnifying in general sense, you are anyways being covered with all the aspects. So you are really don't require another special damage clause for it, but nothing prevents you from even asking that. I hope that Sachin, that clarifies.
Thank you, sir. The next question is from Mr. Amit. And this is a question I think which we all want to know. How can we file a case in court during lockdown phase, like PL, etc.? Is it possible to file a case online in Supreme Court or High Court? Please guide me, sir.
Yes, they are already being filed. Everything is being filed online. You prepare the petition, you scan it, and you file it. You email it. The email addresses, the contact details have been given on the Supreme Court website. The courts have made it very clear. In fact, there are administrative officers, AOs who have been appointed. The numbers have been given. You can call them up, ask them, sir, I want to file a PIL. How do I do it? They will guide you through it. So everything is there. You need to just go to the website and see it. The instructions have clearly been given. But so far as Amit is concerned, I think you can be rest assured that you can file a PIL. They are already being filed online. So nothing to worry on that.
So what about the regular matters in the Supreme Court?
Yeah, unfortunately, the regular matters are not being taken up as of now. Only urgent and important hearings are being taken up. Like I said, for regular matters to be taken up, there needs to be much more infrastructural changes that are needed. So it will take time, but eventually that will also be covered up. Like, for example, initially when we started, the courts were very strict about what kind of matters are being taken. Very few matters were being taken. But now, after this extended period of lockdown, the courts are now broadened the horizon and they are taking up much more matters. They have covered it under the definition of urgent matters. So,
Sumit, going a little ahead of this today's drafting topic, there is another, I think it's a discussion more based question from me now.
right.
Even in the commercial matters also, we have got now stuck up because there is a provision in this act of mediation before the litigation. Right. So since that has not been started, we can't even go to the court before doing that. So because I had a word with the DLSC secretary also, so they said that they are not offering this pre-mediation litigation right now.
Yes, there are in the Commercial Courts Act, there are two things. One is that if there is an urgency, you don't need to go for a pre-litigation mediation. You can directly come to the court. If there is no urgency, that is where it is mandatory for you to go for the pre-litigation mediation. Now, during this lockdown, if there is a hearing which is urgent, then anyways you don't need to go. And if it is not urgent, then you don't need to go anyways. So in both scenarios, I think it is very clear that the provisions are already in place. Pre-litigation mediation today is not available to us. but for the purposes of the Commercial Courts Act. But then that does not stop you.
Hopefully the things come to an regular course soon. So with this, I request Zoya to give it over to Komal so that we can have the thanking note to Sumit Chander, who has explained with an insightful view of this drafting and pleading in this wonderful PPT. Over to you, Komal.
So, so before that, I just want to say the people who have praised the presentation a lot. So I'm getting a lot of messages on that. It is a good presentation with examples and really helpful presentation. Thanks a lot, sir. So these are the people who are thanking you for such a wonderful and full of examples presentation. Over to you, Komal.
Thank you for such an incredible webinar, Sumit sir. It was truly an informative and appellative session. Teaching about this topic was an eye-opener and of great knowledge to us. Learning new perspectives allow us to gain an insight about the laws and the norms of pleading and legal drafting. And during these hard times, we can learn only via digital platforms. So it was a good initiative and the best way to bring everybody closer, share a common platform, and gain as much as we can from such an experienced mentor like you, sir. Thank you once again for an excellent webinar session, Sumit sir. And at last, I would like to thank all our viewers who took out time to attend the webinar session. Over to you, Nitesh sir.
Thank you so much, Komal, for this wonderful note, and to all my team. Because of some technical error, Sana couldn't join us today, but I hope that she would have also been here. So now I would like to thank from the bottom of my heart to Sumit, who has taken out time to speak on this topic, which is very important for the upcoming lawyers and the young lawyers to understand that in what way and manner this legal drafting and the pleadings have to be made. This PPT was very informative. I think we shall look at again and again, and with those, I will repeat that Birbal example was, it just taken off into my mind. So thank you, Zoya. Thank you, Komal, and thank you, Sumit Chander, once again. Thank you to coming on this our board and present with this insightful topic. Thank you so much.
Thank you.
Thank you, everyone.